Hello everyone, welcome back to Ask Prashanthi. I'm your host, an immigration attorney, Prashanthi Reddy, and I'm dedicated to helping you navigate the somewhat challenging and often rewarding world of US immigration law. In this show, we tackle all your questions, all your pressing concerns that you may have about visas, green card, citizenship, and everything else in between. We pull questions from our channel, from YouTube, LinkedIn, Facebook, Instagram, and of course, those excellent submissions from our website. So if you have a burning question, be sure to submit it, and you will hear a response in the next episode. Let's go to the first question. This is from LinkedIn. I'm reaching out to discuss my current situation. I am on H-1B status with an approved I-140. Recently, I noticed that USCIS has been issuing NTAs, notice to appear, even to individuals who are maintaining status. I'm planning to transition to a full-time position with a client and want to understand if this move could also increase my chances of receiving an NTA. Please advise me on whether this is a good decision at this time. Additionally, what precautions should I take? Now, even though the present administration has been sending out a lot of NTAs, they have not been sending out NTAs to people who have maintained status unless there is some criminal record. And by criminal record, I even mean that, they're sending out maybe NTAs for people who have even traffic violations in some instances or criminal violations and who have not faced any jail time. Any kind of conversation that if they've had with the police, that could lead to getting a hit and maybe getting an NTA or getting an RFE. Even if they were not arrested, or any incident that they might have had with the police could lead to an NTA. But that doesn't mean that everybody is getting an NTA, only people who have been in such a situation. Now, what happens when you file your H1? When you file a H1 and if they have a hit on their criminal database, that is, if any FIR was ever filed, I think it's basically for FIRs and not just for talking to the police. So if any kind of FIR was ever filed, even though you are not convicted of anything, even if it was a minor traffic infraction, then what can happen is you'll get an RFE on your H-1B, and in the RFE they'll ask you to go and take biometrics. Then you'll have to go and get biometrics. We were a little worried about those biometrics appointments because we were not sure if ICE would be waiting at at these biometric application centers. But so far, I've sent a few people for biometrics and nothing has happened. Of course, there were only minor, uh, as I said, kind of traffic violations. So once that happens and you get the biometrics and you get proof of it, then you submit proof of that with the RFE. I would also submit something showing that you're a good citizen and you've never been in any kind of trouble with the law except, for that one incident. And maybe you can show how that incident ended. If you were not convicted of anything, if you were maybe convicted of a misdemeanor, then I would submit a final court order. But otherwise, if you've not had any of these issues, I don't think you need to worry. Um, an NTA will not be issued to you. Of course, nobody can say not, but most probably will not be. And thousands of people are filing H1s and with no issue. So I would say go for it. Okay, next question is again from my website. I got a green card 30 years ago, moved to India, did not renew my green card. Can I apply now, reapply for a green card in a different category as a parent, as my son can sponsor me because he is a US citizen? Now, this is an interesting scenario. Most people who maybe had a green card in the past and left the United States and went back to India, they don't usually withdraw their green card, which they should. So in this instance, because I spoke to this person, they applied actually for a B2 and a B1 before that, B1, B2, and he traveled out for work. But when he was applying in the DS form, DS 160, there was a question with reference to have you ever filed an immigrant petition before, something to that effect, and he said no. So to answer the question, there it's twofold. One is, of course, if you've not misrepresented anything and they simply didn't ask the question and they didn't find out and they gave you a B2 visa even though you have a green card, remember, until you abandon your green card, until you withdraw your green card, you continue to have a green card. It's a different matter that they may not let you enter using that green card, and they might ask you to, withdraw your green card application, or put you in removal proceedings because they might presume that you've abandoned status. But of course, that can only be decided by a judge. So they'll put you in removal proceedings, send you before the judge, etc., etc. So that's the process. If you come in with a green card that that is still valid, but you've not used it, and you've been out of the country for more than a year. So this person has been out of the country for 30 years. So presumably the green card is expired as well, but he continues to be a green card holder, just the card has expired. And he can, if not for his travel, he would have been able to renew it after 10 years. Because remember, permanent resident status is permanent. So anyway, in this case, the person did not disclose that they were previously a green card holder. They came into the US. Now their son is a US citizen, so they want to become green card holders again. I suggested that they withdraw their green card by, I think it's I-407 form, applying for withdrawal of the green card, and then with proof that they've applied for that, again reapply for the green card. But the issue here is that there might be some issue of misrepresentation because they did not disclose correctly or answer the question correctly in the DS form. And whether that will be deemed to be intentional or not, they will find out at the interview. Most probably, they can explain that it was not intentional and it was not done in any way for their benefit, because if they disclosed it, it's easier to actually to get a visitor's visa because you're saying that you don't have any intention of immigrating rather than not disclosing it. So it is not to their advantage not to disclose it. So that can show that they had no intent to defraud uh, immigration, the US Immigration Services. Hope that answered your question. The next question is, can I travel outside the US? This is a frequently asked question, so I'm including it. Can I travel outside the US if I only hold a EAD and advance parole? What are the associated risks? Yes, you can, as long as you have an advance parole which is valid. It of course depends on what status you're in. In general, if your adjustment of status based on 485 employment based or family based, there should be no problem. But remember, anytime you leave the country and try to re-enter, you are subject to scrutiny at the border, and there is no guarantee that ever any guarantee that you'll be allowed back in. Next question is again from my website. My daughter turned 14 on July 22nd. We already have a green card, and after that we traveled to Canada for a vacation. We do not remember whether she was fingerprinted or not. Does she need to register again for fingerprinting? As we know now, there's a new law, and everyone over the age of 14 who has not been fingerprinted needs to be fingerprinted now and needs to register to be fingerprinted. So in this case, I would say yes. Rather than being in doubt, it's better to do it rather than not do it if you're not sure whether she was fingerprinted after the age of 14 or not. I would suggest you do that. Next question is again from my website. I'm currently on a H1, have previously been on an F1, got married last October to a person who's a US citizen. How can I initiate the process for obtaining my green card when my husband is the sponsor? In order to do this, you'll have to file an I-130 and 485, and you'll have to file for employment authorization document, as well as advance parole if you intend to travel. It's pretty straightforward, but traveling might cause some interruptions in your work, because if you travel on advance parole, you have to travel on advance parole if it's a family-based case, and when you come back, you may no longer be on a H1, so you'd have to use your EAD, If you don't have the EAD approved by then you may not be able to work until that EAD is approved. And that brings us to an end of another episode of Ask Prashanthi. I hope the questions we answered today helped shed some light on your immigration journey. Remember, understanding your options is the first step and reliable information is the next. So if you have a question you want answered on the show, don't hesitate to reach out to us. Leave a comment right here on YouTube or connect with us on LinkedIn or Facebook, or submit your question directly on the website and follow the link in the description. Thank you so much. See you again next week. Bye bye.